If your business can't pay its debts and you're thinking, what actually happens if I put my company into liquidation? You're not alone. Thousands of directors are asking the same questions right now. So in this video, I'm going to break down the full process in plain English, step by step, so you know exactly what to expect. I know how overwhelming this feels. You got HMRC chasing, creditors are sending letters, even bailiffs might be at your door. And the thought of liquidation feels terrifying. But the truth is, liquidation is a structured legal process. And if you understand it, you'll realise it's not always about punishment, it's about drawing a line in the sand and moving forward. So in this video, I'm going to explain the voluntary liquidation process step by step. I'm going to explain what happens to you as a director as a result of going into liquidation. I'm going to go through what happens to staff, creditors, and the company itself, and the key things you must prepare before starting. So by the end, you're going to know exactly what the process looks like and how to approach it without blind panic. So the first step is deciding whether or not voluntary liquidation is actually something that could be suitable. So in the UK, if your limited company is insolvent, it basically means you can't pay your debts when they fall due, okay? Or your liabilities are more than your assets, or you've had some type of legal action against your company, so like a CCJ. Now, if you answer that A, you can't pay your debts on time, your liabilities are more than your assets, someone's took legal action against you, and then you've got to ask yourself the question, have I got any hope of actually getting this business back onto a firm financial footing? Now, if the answer is no, one of the options is going to be liquidation, okay? Now, the most common route is called a creditor's voluntary liquidation, or liquidation for short. And what that means is you, the director, decide to close the company because it's insolvent and has no hope of recovery, rather than waiting for your creditors or HMRC particularly to force you into compulsory liquidation. And why this really matters is, and listen, this is important, choosing voluntary liquidation almost always gives you more control, less stress, and a smoother process. Waiting until creditors petition the court usually makes things much worse. Now, I want to touch on this, and it's directors' responsibilities. Now, as a director, the minute you become insolvent, you have got to put your creditors' interests above your own, okay? Now, one of the things you've got to consider, again, is can I get out of this? Can I actually get this back on a firm footing? And if the answer is no, you can't make creditors' positions any worse. Because if you do, okay, I'm going to come to this a little bit later on in the video, it could cause you some serious consequences. And if you wait to get wound up, well, the first thing that the official receiver will say to you is, you've not behaved responsibly as a director. You've not took your fiduciary duties. You've not behaved appropriately. Now, let's talk about the step-by-step process of voluntary liquidation. So step one is you speak to an insolvency practitioner or an insolvency professional, an insolvency advisor like us. Remember, I'm not an insolvency practitioner. My role is to help advise you, the director. You know, lots of our inquiries don't end up in insolvency. It might be finance and it might be negotiation that you need. But if you need to go through liquidation, you must use a licensed insolvency practitioner. A liquidation can only be carried out by a licensed insolvency practitioner, okay? Now, a licensed insolvency practitioner, they're not necessarily working for you, they're actually working on behalf of the company, okay? So legally, they're advising the company, not the director. It's an important point, that. And they're there to represent the creditors, okay? But you still need to appoint one, okay? You can't do a liquidation on your own. Please, dear God, if someone offers to buy your business off you, but you've got to pay him £5,000 to do so, run a mile, okay? You must use a licensed insolvency practitioner. Now, once you've spoken to your advisor, your insolvency practitioner, and they've agreed that actually the right option for this business, for the creditors, is to put the business into voluntary liquidation, What they're going to do is they're basically going to give you details. They're going to need some information off you. They're going to send you a shopping list of info that you've got to give them. And the next thing, there's something called the board resolution. So the directors of the company, they hold a board meeting and they resolve that the company can't continue due to its debts and that it should go into liquidation. Now, normally, immediately afterwards, you get shareholder approval. Now, at least 75% of shareholders by value must vote in favour. Now this is usually just a formality, okay, because most directors agree, but sometimes there'll be two directors, 50-50, and one director wants to and one director doesn't want to. That's a problem, especially, if they're not just directors, but the 50-50 shareholders as well. You've got to get 75% of shareholder approval to approve the liquidation. Now, the next step is the actual creditors meeting, and people really panic about this creditors meeting. And what it is, most of the time nowadays, they're virtual, they're done on the phone. And it's where creditors are formally told that the company is insolvent, the insolvency practitioner is confirmed as a liquidator, and your creditors can ask questions about what went wrong. Now, we are probably involved in about 50 insolvencies, 50 liquidations, maybe not 50 actually, probably 30 liquidations a month. And I would say in 95% of those, the creditors don't turn up, but in some cases they will, okay? Now, if a creditor turns up to the creditors meeting, they can ask you questions about the company insolvency, okay? What you might also need to be aware of is when you're going through an insolvency, when you're going through a liquidation, remember 75% of every creditor gets a vote on who is the appointed liquidator, okay? And it's the majority of creditors who get to vote who that insolvency practitioner is. So sometimes, every now and again, what you'll find is other creditors have gone round with votes to get proxies, and at the creditors meeting, they could actually come and try and appoint their own insolvency practitioner. If you want specifics about that and how it might affect your case, please, pick the phone up. In fact, anything I've said so far that's grabbed your attention, go to the link at the top of the description, put your details in, one of my team will call you today, okay? Now, once the creditors meeting's happened, the liquidator takes over. Now, the liquidator is not, the other name for a liquidator is an insolvency practitioner or IP, it's all the same thing. They take full control. And by this stage, the company bank accounts will have been frozen. They're going to look for some assets in the business, and if there's still assets, they're going to look to sell them, and that might be via auction. It might even be back to you as the director, or they may have buyers lined up for the type of assets that you have. The creditors will have been notified and claims of the creditors are collected, because each creditor is going to go, well, you owe me this and they owe me that, and they're trying to verify what them claims are. And then the liquidator is going to investigate your conduct as a director. They're going to look at things like overdrawn directors' loan accounts. They're looking at dividends that you've took when you shouldn't have took them. They're going to look at your bounce back loan as to what actually you spent your bounce back loan on. Did you take the right amount? Was you eligible to take one? And from this point of the creditors meeting, you are no longer in charge of the business, okay? Now, what I want to talk to now is sort of what happens to stakeholders, so sort of like employees, creditors. First of all, staff are made redundant, okay? Now, when they're made redundant, on the creditors meeting, they'll be given a case reference number, and they can claim unpaid wages, they can claim holiday pay that's been accrued and not taken. Everyone can claim that who's an employee. If they've been with you over 2 years, they're also going to be entitled to statutory redundancy pay. And they're also going to be entitled to notice pay. Now, notice pay is a little bit different because they are paid as compensation for not being given the right notice period. And it depends on how long they're actually out of work. They'll claim all of this from the redundancy payment service. Now, if you are a director who's out there who's worried about your staff, one of our team can assist you, educate you about redundancy, and we can also have a point of contact for your staff so we can educate them about what's to happen. Next thing I want to talk about is your creditors, because your creditors are ranked in order. You've got, and they're ranked in order for a reason. These are the people who are going to get something back out of the insolvency if there is a dividend that's going to be paid to creditors, okay? So the order is secured creditors first, okay? Preferential creditors, people like HMRC, and then you've got unsecured creditors, and then you've got connected parties, okay? In most cases, unsecured creditors get very, very little back, okay? If you imagine, let's say there's a £50,000 dividend going back to creditors after the charge holder's been paid, but you owe HMRC £100,000, HMRC gets all that money. Nothing goes back to the unsecured creditors. And obviously what happens to the director? Well, as a director, you're investigated. Now, you're not automatically penalised, okay? Personal risk, it only arises if, let's have a look at them. You've signed a personal guarantee. Your director's loan account is overdrawn, or you've traded wrongfully. Otherwise, once the process is complete, you can move on. But I'm going to dig into those three things because they're really important. Personal guarantee. Loads of directors sign personal guarantees knowingly or unknowingly. And what it means is if the business defaults and it doesn't pay back the supplier or the credit card or the loan, and it goes through an insolvency process, your personal guarantee is going to get claimed upon. And what that means is they're going to write to you and serve notice and say, I want my money back. Now, the reality is in 99% of cases, you'll be able to do some type of negotiation with the personal guarantee. And that might be, most people decide to extend it over a longer period of time. You can cap it interest. You can even reduce payments for a while and then step payments up as you get back on your feet. Or some people offer full and final settlements. I've got someone you can speak to if you're really worried about personal guarantees. In fact, I've done a podcast with this guy, Gary Whitehead. Go and watch it. It's really good and it'll give you a little bit of hope. And then we've got the dreaded overdrawn loan account. So, for those that haven't watched the video before, an overdrawn loan account for me is the number one problem for directors at the moment. And it means that the director owes the company money. Now, the best way for you to check whether you have an overdrawn loan account is to have management information. So whether it's Xero, Sage, QuickBooks, Free Agent, and you update this, you've got to update it, right? You pull off a balance sheet, you will see your director's loan account, or it might call it director's advances, or it might be in the debtors section, someone that owes the company money. Now, if it's overdrawn, the insolvency practitioner is duty bound. They've got to try and ask you to pay that back once you go through insolvency. That's part of their job, is to try and recover that as an asset of the business so they can distribute some money to creditors. Now, you really need to understand this up front. That's my advice to you. And if you don't have the management information, you should get it. You need to get a bookkeeper. Any business owner that doesn't have a P&L every month and a balance sheet that they're reviewing is on really thin ice, especially if things go wrong. Now, your accountant might have your bookkeeping, so you can ask them. If you're having to go back to your last set of accounts to check your director's loan account, that's a big red flag for you, because your statutory accounts are a snapshot of your business one day in the past. And let's say your accounts are 18 months out of date, but you've continued to take money out of that business that's not through the payroll, the chances are your overdrawn loan account has increased significantly. And you are going to be asked to pay this back once you go through insolvency. Now, the key for this is to get a deal done with an insolvency practitioner. What we want you to do, if this is worrying you, you must pick the phone up to us quickly, and we'll help educate you about what your director's loan account is, what you could do about it as well, so you get some clarity and peace of mind. Deals can be done with insolvency practitioners once they become appointed, okay? And it's really dependent on what your personal wealth is. If you're in £1 million house with no mortgage, this is quite difficult to solve. You really need some help. If you are in rented accommodation, it might even be written off. And there's a whole different, many different ways to solve directors' loan accounts once the IP has been appointed. But the key thing is you need to be well aware of what it is and be going to them with this information. Again, when it comes to overdrawn loan accounts, we can really, really help you understand your position and what the options might be. Now, next thing, finally, is wrongful trading. Now, wrongful trading is essentially you are taking deposits, you are racking up debts with suppliers with no hope of recovery, no hope of paying those suppliers, no hope of fitting those jobs. That could land you into serious, serious trouble. Disqualification, personal liability notice where you're made liable for some of the company's debts, or even in the most serious cases, people go to prison. So, we're now at the end of the process. When all assets are realised, creditors are dealt with, investigations are completed, the liquidator will file final paperwork and the company is eventually struck off at the register at Companies House. Now, from this point, the company no longer exists. For many directors, the liquidation process can be painful, it can be overwhelming, and it can be stressful. But it is also a clean slate, and it draws a line under the unmanageable debts and lets you move forward. People ask me, how long is it going to take to disappear off Companies House? Most IPs want to get it done in 12 months, but for more complex cases, it can go on for years and years. Now, before you start the process, what I think you should do is have all your records together, bank statements, accounts, contracts, leases, management information that's up to date. Remember, check your director's loan account. Know if you owe the company money. I cannot hammer home this at this point. And if you do owe the company money, you really need to take some advice about how that might be dealt with once you go in insolvency. Again, this is something you need to reach out to us for. Review personal guarantees. Be clear what you're liable for personally. And be honest from day one with the insolvency practitioner. Hiding things will only make it worse. Preparation makes the process smoother and it reduces the stress, I promise you. So what's the process for putting your company into liquidation? You appoint a licensed insolvency practitioner, you hold a board and shareholder meeting, you notify creditors and the liquidator takes over. Assets are sold, creditors are paid in order of importance, staff can claim their redundancy through the redundancy payment service, and eventually the company is devolved. If you're a UK company director thinking about liquidation, don't go into it blind. Contact us at Director First today. We'll explain your risks in plain English. We're going to protect you from personal liability where we can. We can't sweep things under the table, but we can certainly educate you about what might happen, and we can guide you step by step through the process. So, if you've enjoyed this video, what I want you to do, I want you to go and click this, and it's going to tell you all about the things that you need to do before you put a business into liquidation. It'll answer lots of your questions. Thanks for your time, Chris Worden.